we'd like an interpretation. The Celestine Mukandila Munia Zulu versus Attorney General case, did it consider the process of Bill 7 flawed when it said against the spirit of the Constitution? Is the technical committee and the whole process void ab initio, State Counsel?
Thank you very, very much. Turning to the issue of the Munia Zulu, Mr. President, if you read it, the Munia Zulu judgment says in one portion, and I will quote, "Accordingly, we hold that the Constitution of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity." That is in black and white. That is not distorting what the court said. It is quoting directly what they said.
But stemming from there, quoting the Celestine Mukandila and Munia Zulu versus Attorney General, State Counsel Haimbe, you say you have the law that you want to quote for us. In 2 minutes, State Counsel Sikota says the court says it's a nullity. It's unconstitutional. So where do you draw the strength that this process is legal? Your 2 minutes.
Thank you very much, Costa. And again, interesting that we always have different interpretations of reality. Quite clearly, we can see that our colleagues who are not in support of this bill have got a distorted understanding of the reality. I note that State Counsel, in quoting what he says is this decision, the Celestine Mukandila case, did not specifically mention which paragraph he was quoting. But suffice to say, and again looking at the 2 minutes, the actual decision, which is at page J25, paragraph 56 of the decision, does not speak to any of the matters that State Counsel has referred to. Maybe he's talking about something that was said obiter, but I didn't find any of that within the reading of the judgment. What does it actually say? In the reliefs that have been granted, it talks about, and I quote, "We declare that the decision of the respondent to reinitiate a constitution amendment process before undertaking wide consultations with people goes against the spirit of the Constitution." There is no mention of it being null and void. But more importantly, it states in paragraph 2 of the holding, which is what the court says you must follow, "We order that the respondent complies with the spirit of the Constitution."
I'll allow you to finish. Just take note of that. I'll allow you to finish.
We order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts in conducting wide consultations with the people. The question then is, what did the court order? It said wide consultations. It didn't say stop the process of amendment. It didn't say now and void in its decision. Let us be honest with the people and speak to what is actually there.
Thank you. Director, if we could just also beam the judgment on the screen so that we follow. You've been quoting page
J25, paragraph 56. 1 and 2.
State Counsel Sakwiba Sikota, you've been challenged that what you're quoting is not from the judgment. What is your response in terms of why you feel that this process is an illegality?
Thank you very much. It's interesting that my learned colleague states he has read the judgment, and he says that those words I've read out are not in the judgment. The truth of the matter, which he knows very well, is that those words are there. He tried to have an escape clause by saying that, oh, maybe it was obiter. That is what he says. But as to whether or not those are there, they are there. And he knows it. And that is a fact.
Now, take note. He says, and that is a fact. But he does not go to the judgment to quote exactly which page, which paragraph he was quoting from. Let's go on.
Now, the final ruling of any judgment states that this is now what we order. But in the run-up to that final holding, they give the reasons why they are going to make that order. Now, the reasons why they were saying that that process has to be restarted afresh is because, according to them, the Constitutional of Zambia Amendment Bill number 7 of 2025 was not generated through a constitutionally compliant process and is therefore unconstitutional, invalid, and a nullity. When something is a nullity, it means that it does not exist. We have to look at the whole thing holistically and confirm that the court said start afresh.
Thank you. There still remains an unanswered question here. State Counsel Haimbe is saying the court ordered that the process be started afresh, and this is
No.
correct? Well, you believe that the process, based on what the court said, is legal, and the formation of the technical committee allows for wider consultation, correct?
Yes, and if you allow me to elaborate, you said...
So what I wanted to do,
yes.
I'll give 3 minutes for each one of you. I won't intervene, but I'll allow for you both to exchange, because what is interesting here for me and the nation, we've got 2 state councils who are failing to agree on one court judgment. So then for laymen, it's even more confusing. So I would like you to enlighten us. What did the court order? You're saying it's a nullity, it should start all over afresh. What are you saying, State Counsel Haimbe?
Okay, and this is where it becomes imperative for us not to read words into a judgment. That's where we begin to have problems. When colleagues want to massage a judgment, clear words of the highest court, an apex court, that puts forward the decision that they have made. You cannot do that. You cannot put an interpretation of what you want them to have said in a judgment. Now, I'll go back, and we all know this, that the decision of the court is contained in the orders that it makes, in the reliefs that it grants. And I'll read again, for the avoidance of any doubt, and I'll ask that our viewers are able to go to this judgment. It's available online. Simply look for the parties of the case. Type in your search engine, Munia Zulu and Celestine Mkandila versus the Attorney General, 2025 CC said 009, and you'll be able to follow. We must have the truth when we deal with these matters. And the court said this: accordingly, we grant the following relief, which I read earlier. We declare that the decision of the respondent to initiate a constitutional amendment process before undertaking consultations is against the spirit. Okay, that's the first holding and finding and decision of the court. The second is we order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body of experts. Yes, it's there, so the people will follow it. Now, in those words, do you see anywhere that the court said start afresh? Nothing. In those words, do you see anywhere that the court said that this process was, it is a nullity? There is nothing to that effect. In any of those holdings that I have read, does the court say that Bill 7 is now and void ab initio? It doesn't. It doesn't even declare it unconstitutional. And we have to look at this from the perspective of what those applicants asked. They asked, the petitioners asked for certain reliefs, which included the following, and I quote, a declaration that the decision of the respondent to undertake constitutional amendment process without undertaking wider consultation, etc., is in breach of the Constitution and thereby unconstitutional. Number 2, an order directing the respondent to undertake wider consultation with the citizens of Zambia prior to tabling of a constitutional amendment bill. And third, that the process be halted, amongst the various reliefs that they sought. Did the court grant any of these reliefs as put forward? The answer to that question is no. The court did not say halt the process. There is nowhere in that holding that the court said that. In fact, the court said undertake a process similar to that which was undertaken when President Sata appointed a technical committee. So what I am saying is, let's not read or embellish the judgment. The judgment gives clear directive that this is what must be done. The judgment, by the way, does not go further to say that do it in this particular form. It simply says that we must follow a process of wide consultation.
So looking at the screen and the judgment, State Counsel Sakwiba Sikota, again, for the sake of the public, you are both state councils. What does it mean in 2? We order that the respondent complies with the spirit of the Constitution by ensuring a people-driven process led by an independent body. State Counsel Haimbe is saying the court never said the process should be halted.
Thank you very much. I think that the people of Zambia should realize that This is, how many pages long is this judgment?
The majority judgment is 25 pages.
25 pages. The 25 pages do not consist of only this, which is on the screen. The 25 pages give the reasons why they're making the judgment. They were not just sitting there, just filling up space. It has got a reason why it is that length. The 25 pages do contain this statement. Accordingly, we hold that the Constitution of Zambia, I can't quite give it to you offhand, but it's in the judgment.
There you are. There you are. That is a state council, Sakwiba Sikota, quoting something that is not in the judgment. Quoting something that is not in the judgment. This is what I've been telling you. People are not being truthful. People are not being truthful, including lads. They are not being truthful. I have been challenging you. I've been saying, can these people point to us where the court said the Bill 7 is unconstitutional? Where did they say that? And there is Sakwiba Sikota confidently reading something which he cannot point to in the judgment. I'll play it again. Let me play it again so that you hear.
That the Constitution of Zambia, I can't quite give it to you offhand, but it's in the judgment. I can't quite give it to you offhand, but it's in the judgment. Keep in mind.
State Council, just a rider. When the judgment is concluded, there is a ruling and an order. What did the court order? What did the court order the respondents to go and do?
No, what is important is what was the reason for the court action? What was the analysis of the court? And how did the court think, okay, we can have this matter resolved in this way?
The challenge is he is not quoting the judgment. He keeps talking about nullity, 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 but he does not go to the judgment and tell us where that is written. And the question again from Costa was very specific.
Process. The court went back and said, let's look at the initiation of the process pursuant to our power under 128C. Therefore, the court did not look at, by the way, this action commenced prior even to Bill 7 being tabled. So to suggest that the court addressed its mind to an issue that did not exist at the time that the matter was commenced is being a little bit mischievous. But specifically, the court said, we'll look at the initiation process. We'll look at how this whole thing was started. That's where we'll confine ourselves. And the decision that was made did not speak in any way, form, or shape to the provisions of Bill 7, because it was not in the contemplation of the court. The court, in all its substantive reasoning, spoke about the initiation process. How did this whole thing start? Very, very crucial. And the court then goes and says, we would want you to follow as much as possible the process that was undertaken under the TCDZC process. That is the Technical Committee on the Drafting of the Zambian Constitution, appointed by President Michael Sata in 2011. That was done through a technical committee process where the president invoked his powers under Article 44 and 33 of the Zambian Constitution as it then read. Currently, the technical committee was appointed by President Haimbe pursuant to his powers under Article 92 of the Constitution, and in particular, there is, I think, sub-article F, 92 2F, I believe. But we can go to those details. Those provisions are mirror images of each other. So if there is a precedent that existed when President Michael Sata appointed the TCDZC, that precedent has been declared, in fact, lawful by the Constitutional Court. And therefore, the same process that was followed by President Hichilema is lawful.
In conclusion, was Article 79 of our Constitution violated in this process?
No. Not in any sense. As I said earlier, the court did not even speak to the issues of Bill 7 itself. The question that was raised is, can this process be undertaken in the way that it has been commenced by government? Amongst the questions that were being asked by the executive. And the court said, we have a general power under Article 128C to inquire into the actions and decisions that are taken. So it did not even refer specifically to the provisions of Article 79 per se in determining that this matter must be concluded in this way. It looked at how the process was initiated and said the precedent we have in this country is that we have commissions, we have other modes by which these processes of consultation must be undertaken, and then said, government, you must do this in substantial conformity with what President Michael Sata did.
You want to rebuttal?
Yes,
certainly. I'm giving you 30 seconds.
Now, what is very, very clear is that the whole Munia Zulu matter was about Bill 7. Everybody knows that. Everybody knows that that is what it was about. And you cannot talk about that, oh, they were talking about how the process was initiated. What process? Process of what? Process of Bill 7. Nothing else. And what we must look at is, let's sit down and say, what was Munia Zulu and Mukandile asking? They were saying that this process of this new bill you're trying to introduce is wrong. Which is that bill? That is Bill number 7. That is what was being taken to the courts. And we must never forget that.
Unfortunately, I beg to differ with State Counsel Sakwiba Sikota when he says that the judgment was about Bill 7 because the process led to Bill 7. Yes, the process led to Bill 7. But the court action was not about Bill 7 because by then, Bill 7 was not yet born. Yes, the process was led to Bill 7, but unfortunately, when the court action was commenced, Bill 7 had not started. Now, why do I say that we cannot jump to Bill 7 in the context of the judgment? Because these people, the evidence they gave on what had happened. They had not given evidence on what was going to happen. I hope you follow me well here. They gave evidence. Their submission was based on what had already been done. And so they are saying, out of what has been done, is this okay? Is this constitutional? Out of what has been done, not what was going to be done. What was done? Two things. President Hakainde Hichilema said that, I think we have agreed that we need to amend the constitution. And secondly, the Minister of Justice went to Parliament and made a ministerial statement. So it is based on these issues, not what was going to happen, because what was going to happen and what has happened after the court case had started was legal. What had happened? What had happened is that the bill was presented, was prepared, and it was gazetted according to Article 79. Is it 79 or 76? The law was followed. Thereon, everything was followed. Their issue was that, no, how can the president say, we have agreed? He has agreed with who? That was the issue. And then the minister has confirmed this. That is what they spoke about. Not what followed after, because what followed after, we have the Gazette, we have the technical committee, we have the parliamentary committee sitting at Parliament receiving submissions from people. So, at the time that these guys were going to court, yes, there was no consultation. But what happened afterwards? There was consultation. So there is a difference here. You cannot say, this judgment is talking about Bill 7, because no, Bill 7 was not born, and everything around Bill 7 has been constitutional. Anyway, I have to go, I have to sleep, but I must say that Mulambo Haimbe did very well. Mdala Sakwiba, no, he could have prepared himself better, but I don't think there is anything that he could have done, because the truth is, Bill 7 is legal. Bill 7 is legal. The issue of wider consultation, I think we have been on that for a long time. I've been insisting that what is contained in Bill 7 is not something new. It is something that we have been discussing from a long time. So, we can't pretend that, no, the UPND brought in something that is completely new. No, they basically picked something that has already been in the public domain, and somehow we have had a consensus. How have we had a consensus? We had a consensus when we had the NDC. When we had that dialogue forum, we reached a consensus, and it went into Bill 10, though Bill 10 was short. But the issues, we had agreed on them, and UPND simply picked those issues and came up with Bill 7 of non-contentious issues. So, from my perspective, I am looking forward to this bill going through. I hope members of parliament will not be emotional, will not be partisan, will not be misrepresenting like we have seen with the Sakwiba, because really he was misrepresenting facts. So I hope members of parliament, they will transcend the political divides, emotions, and battles, and do the nation a favor by voting for Bill 7. Good night, my brothers and sisters.